Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets, such as patents, trademarks, copyrights, and trade secrets. I'm your host, Tom Bergert, and today I'll be joined by my colleague, Drew Shores, a senior associate in our intellectual property practice group here at Williams Mullen, to discuss 5 popular misconceptions about patents. Drew, welcome to the podcast.
Hey, thanks, Tom. Great to be here.
So there are many confusing things about many areas of law. And I had a former colleague that used to say tax laws used to make his hair hurt. And I actually welcome that as a thought and a possible condition. But since I can't do that anymore, I will walk into the notion that we work in, or the area that we work in, of patents, and the fact that there are many misconceptions about patents, not only for those that are new to the field, but also for those that are experienced and have been inventors over time, or owners of or companies that have owned patents. We've got several misconceptions to talk about today, and I thought I'd start with the first one, which we often hear, which is getting a patent means that I am the only one who can make, use, or sell my patented product type. Have you heard that before, Drew? And what are your comments?
I have many times, and no, that is not the case. It's a common misconception among both novice and experienced patent savvy folks. A patent doesn't give you the right to practice your product type. It gives you a right to exclude what is claimed. And what I mean by that is, and when we talk about patents, we've got drawings and a detailed description that describe the invention, but what really matters are the claims at the end of any patent. And that's what really defines the invention and gives you the definition of what you have the right to exclude others from doing. Best to talk about it in a way of an example. So if we were to think about me as an inventor and I get a patent on training wheels for a bike, and what's new and novel about my training wheels is that they have 4 wheels instead of the 2 that we commonly think of when we think of training wheels. Now, when I get a patent issued for that, my claims require that the training wheels have 4 wheels. Does that mean that I can necessarily sell 4-wheeled training wheels, or does that mean that I can stop others from selling them with 2? No, it doesn't. If somebody's selling historical or typical training wheels with only 2 wheels, there's nothing I can do about it because they don't have the 4 wheels required by my patent. Another example is like a chair, 4 legs, a seat, and a back. I got a patent on my chair, and I think I can stop all others from doing that? No, not the case. Someone could come along and just have 4 legs and a seat with no back, make a stool. They'd have no problem doing that, not infringe my patent, and there's nothing I can do about it. That's a common misconception we hear a lot. Tom, tell me if you've heard this one. I've got another one. Getting a patent means I'm free to make, use, or sell my invention. A little bit related, but slightly different. You ever hear that one before?
Yeah, we hear that a lot, and it's something that is sensible, at least from a high level. Okay, I've gotten a patent, now I'm the owner. And you might think in terms of a trademark. I've registered my trademark, now I own that trademark. Well, it's a little different with patents. As you pointed out, the patent right is a right to exclude. You exclude others from making, using, selling, importing, offering for sale the claimed invention. So getting back to your description of the aspects of the patent application, the claims are the most important. There's a famous quote in our field: the name of the game is the claim. So what the claim says determines what you can exclude others from doing. And your example of the bicycle training wheels is right on point. You may have a patent on training wheels, but if you're going to sell a bicycle with those training wheels, you may not own a patent in the bicycle. There may be a patent on the bicycle, the underlying product, and you are not then permitted to sell the bicycle with training wheels without permission, or under something called the first sale doctrine. If somebody were to buy the bicycle, they could buy your training wheels separately, and then they would be able to have that combined product. But you can think about so many different products that are out there that are a compilation of patent rights, electric vehicles, the iPhone, so many different aspects of intellectual property associated with those devices that getting on a patent on one aspect of those types of devices, or whatever your invention may be, doesn't say that, and it doesn't mean that you have full ownership and you're the only one that can sell that product. Another one, Drew, have you heard this one? So this is for the patent applicant. They filed their patent application, they get a first action rejection. So the misconception is I've gotten a rejection in my patent application. Oh no, that means somebody else has rights to what I want to do. My business can't go forward. I'm dead in the water as far as actually practicing what I've invented.
Yeah, that's one I've heard a lot. And I have to talk a lot of folks off the ledge on this one after we get that first action response. The issue here is that you don't need a patent necessarily to practice your invention, right? It's just the right to exclude others. If I apply for a patent and my business is built around this invention, I'm trying to build up this new novel idea into the market, and all of a sudden I can't get a patent on it, I'm not dead in the water. The only time there's a problem is if somebody has a valid issued patent that might cover what I'm trying to do. And that's a small scope of what's known as prior art that goes into determining whether something is patentable or not. When the patent office is looking at my patent as an application, they're looking at all prior art. This can be textbooks describing it, scholarly papers, and oftentimes old expired patents or patent publications that are no longer enforced. So does that mean I can get a patent? No, there is something out there describing what I'm trying to invent. It's not novel. It doesn't meet the conditions of patentability. So I can't get a patent and get that monopoly right to exclude others from using it. But it doesn't necessarily mean that somebody else has that monopoly right and can exclude me from doing it. It might just mean I have to go out and compete in the market with others who might want to copy it or compete with me. But that's okay. That's just good old-fashioned competition. Doesn't mean the business is sunk, and by no means a thing to get worried about going forward. But that's a common one, because when you put all that effort into an application, it doesn't go through. Oftentimes you think, oh man, that must mean somebody else is doing it. Not necessarily the case. And that's something you'd want to talk about with your patent attorney and think about going forward.
And so the disclosure, Drew, just to follow up on that, the disclosure of whatever prior art is being cited by the examiner could be in a description, it could be in a drawing, it doesn't have to be in a claim that could be problematic. It could be an article, right? There could be something that was written 15 years ago or published in a trade journal. It can be used against you, right?
Yeah, that's right. The famous example I think they teach in law school is the random PhD thesis on a library shelf in some obscure university in Germany. Is it publicly accessible? No, it wasn't online. But was it disclosed in a writing somewhere that was ultimately found and used to invalidate a patent? It sure was. But that PhD publication isn't going to stop you from practicing your invention. It's just going to stop you from getting a patent on it. That's all. Two very different things. Moving on, we got another misconception here, Tom. Wonder if you could speak to it. If the prior art did not claim my invention, I can get a patent. These are kind of related, but also a little bit different. Can you speak to that?
Yeah, and so we'll hear this with patent applicants. So the examiner comes back with an office action citing some prior art, and the prior art may have subject matter in a paragraph that describes something relevant to what you're trying to claim and patent for the applicant. And the applicant says, well, wait a minute, it's not in the claims. Like, I'm fine, I've read through the claims. I don't have a problem with that. The claims require so many limitations, and I don't do that. So consistent with what we were just talking about, the disclosure itself, whatever prior art object is being cited by the examiner, it could be a patent reference, it could be a non-patent reference, but if the disclosure itself provides the examiner with a basis for refusing the claims of your application, either because it says all of the claim, it anticipates the claim, or it renders it obvious in the mindset of the examiner, that's enough for your claims to be at least initially refused. There's always a back and forth option available, so you can file arguments and amendments to try to get your claims through, but that disclosure can be anywhere. It can be in a pending application that's published, it can be in an issued patent, it could be an expired patent. So wherever that content is that the examiner is relying upon for the rejection, it doesn't have to be in the claims. So just because your invention is not in the claims of the prior art reference doesn't mean that that you should get a patent.
Yeah, that's a good one too. A lot of times you'll see patents cited and it'll actually be the background. So it's just relevant background to the invention being described in some other patent that the examiner will cite. Client will say, but hey, it's directed to a completely different invention. I don't do that. But yeah, to your point, it's in the publication. It's discussed, whether it's background or in the claims. It's all prior art and relevant to patentability. It's a good point.
And finally, misconception number 5, which we hear in so many different flavors, and I'll capsulize it this way. Getting a patent means that companies and people are going to line up to pay me money.
I wish that were true, Tom, but unfortunately it's not. Look, patents can certainly be valuable, but more often than not, they are directed to narrow inventions in a crowded field of stuff. And you not only have to get the patent, but you've got to convince somebody else that it's worthwhile. Now, that's something that can happen, but patents are obscure. People don't necessarily know about them. People aren't going to come beating down your door because they're monitoring the issued patents that come out every Tuesday. They're hard to identify and hard to find. It takes effort on the patent owner's part to go out and kind of sell the patent and demonstrate its value, both in that it's directed to something that is marketable and can be monetized, and also that the patent itself is strong. A lot of patents get challenged as being invalid. Large companies have big budgets to try and validate patents, challenge patents, make it really difficult to enforce patents against them. And all these costs can add up. Now, I don't want to say that no patent is valuable. That's far from the case. And today, with the patent data mining that can be done and the internet and the ability to quickly search for information and analyze these claims more efficiently, venture capitalist groups and other groups that want to invest in new technologies and patents can certainly line up. But it's not something that's going to happen automatically. It is certainly not a lottery ticket. It can take a lot of work after you get the patent, which itself, as you know, is a lot of work.
Yeah, and I think there's a reason why there are more than 11 million U.S. patents out there now. I think part of it is a lot of people feel like it can be a lottery ticket, but also a lot of people are making very smart decisions and investing in their intellectual property. And I think a concerted effort to do that in a broad mindset when approaching these types of issues can be very helpful to try to improve your chances for monetizing whatever patent rights you might be able to get.
Keeping that patent portfolio can also be a great defense too. It can help keep others from asserting patents against you if you have your own portfolio. So there's a lot of value there in just getting patents and holding on to them, not necessarily enforcing them against others.
Good point. Well, thanks for your time, Drew. That wraps up our discussion on 5 popular misconceptions about patents. I'd like to again thank you, Drew Shores, for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find more about our team as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.